viewers know. If I've been the victim of a malpractice, a doctor did something wrong. I know there have been cases where the wrong arm has been operated on, or something's been left inside the body, and so the person has been harmed. Under our Constitution and our national Constitution, we have a right to file a lawsuit.
That's absolutely right.
And let's talk about what that lawsuit is before these tort reform rules would be. What would you be seeking in a lawsuit?
Well, what an injured person would be seeking in a lawsuit is that first, the lawyer for the injured person has to prove that the doctor who, let's say, operated on the wrong knee, for example, and you have to prove that he operated on the wrong knee. You have to show that he did something wrong. He did not follow a rule. He broke a rule. He violated patient safety rules.
And the standard of care.
And the standard of care. Now, everyone can agree that if the chart says operate on the right knee and a doctor operates on the left knee, that's wrong. That should not have happened. What gets more difficult is that when there's an operation that takes place and something goes wrong in surgery, and whether the proper procedure was used. They follow the standard of care. Or a lot of times you see there's misdiagnosis of a condition and the wrong treatment is given and a child can die, for example. Another example is sometimes I've seen cases where children have been given adult dosages of medication, so it's the wrong prescription. Now there are rules in the books that says what the prescription should be. So these doctors should be held accountable for violating rules that were created by their own profession.
Now, if you want to file for a client a medical malpractice lawsuit, you have to include something called an affidavit of merit. And let's tell our audience what that means.
In Delaware, before a lawsuit can be even filed, the lawyer needs to consult with a medical expert in the field where the malpractice is being alleged. And that doctor has to read their medical records and state within reasonable medical probability that the accused doctor in this case did not follow the rules, the standard of care. And if you can't get that report from that doctor, then you do not have a case at all. So it's very difficult. I mean, this takes away of any fear of frivolous lawsuits. There's no such thing as a frivolous lawsuit being filed in medical malpractice claims in Delaware. It's just not possible to happen.
Well, you've talked about the affidavit of merit, but isn't there a great expense for the law firm if they're going to file for a particular patient?
This is a very sad thing. There are a lot of people who come to our office and there may have been malpractice committed. However, the damages are not so significant, so severe, that it makes sense to hire an expert to do the analysis and then litigate the case, which can cost $100,000 to $150,000 to try a malpractice case. So you have a case that's worth $10,000. A lawyer who's watching the bottom line is not going to file a lawsuit in that case.
So the law firm often will front some of these expenses because the client is not in a position to pay that too.
Absolutely. I mean, I only aware of very few law firms who ask the injured party to come up with some money.
So under current law, what you're telling us is that if someone's been a victim of malpractice, if a lawyer wants to file a lawsuit, he's got to get an independent doctor to sign an affidavit that a breach of care was done, and the lawyer's probably not going to take the case because of the amount of time involved and the costs involved, unless it's a solid case.
Right. And because of this procedure that's unique to Delaware, is that